my dragons. How are you doing this week? Hope you're doing well. I'm getting ready to go up north to do my research, and thought I'd go over some of the things from this week's class so that can be explained or discussed a little bit more when we actually do post. So this week's class is all about insanity, competence to stand trial, civil commitment, those kinds of things as well, and mental health law. So one of the things we have to know is the difference between competence to stand trial and insanity, okay? So competence to stand trial, the big difference is what does the person look like at the time of the hearing, okay? So an incident will take place, the person who is been caught either doing something, murder or an altercation or whatever, and they are arrested or put into a facility, medicated. And so what you see in court is not always, at the hearing, is not always what the person looked like at their worst or at the time of the offense. So at the time of the offense, what we call MSTO is the definition for insanity. And it's important for you to remember that insanity is a legal term, not a psychological term. I think you guys all know that. And for competence to stand trial, they have to be judged by what's going on at the hearing, and they have to be able to assist in their own defense, which is a really big part of competence to stand trial. So your PowerPoints go over a lot of different important cases. Assisting in the attorney, with your attorney at the hearing comes right out of the Dusky case. Do you have sufficient understanding to know what's going on? And then there were several other cases that looked at competence, different types of competence. We have a whole list in your PowerPoint, like competence to be executed, competence to execute a will, competence to make a plea, all kinds of competence. So make sure you go over that to understand what we mean by competence. The other thing is that you will see that, again, there's differences between the states. There's not one uniform thing. So a lot of states have their own definition of competence and sanity/insanity. So you're essentially taking a psychological term, and the law is taking it and making a legal term from it that does not cover the complexity and all the variation that you find in a psychological format. So they don't have the whole DSM in there. They're just defining it in a legalistic and, according to psychology and psychiatry, a rather narrow look at competence and mental illness, okay? So there are also different standards in terms of evidence, okay? So in the Cooper case, which you can look at in the PowerPoints, they're looking at clear and convincing evidence, which usually that standard you see in federal cases, okay? You're all familiar with beyond a reasonable doubt and preponderance of the evidence, and clear and convincing is just yet another standard. In the Medina case, it is preponderance of the evidence in those kinds of cases. So one of the things that, well, there's several things that you can have a ruling of, yes, this person is incompetent, they can't stand trial, so this is what's going to be the rule. So some of the reasons that you can be found incompetent would be dementia, Alzheimer's, a developmental disability, things that interfere with your reasoning ability, bipolar disorder, major depressive disorder, or they're in the midst of a psychotic break, okay? All of these different things makes it impossible to assist in the defense, and it makes it difficult for them to understand what is actually going on in the case, okay? So insanity is not the same from state to state, and a lot of times it's very perplexing to us. So when you take the case, this is a very famous comparison between Jeffrey Dahmer and John Hinckley. So John Hinckley has a delusional disorder, and he's going to impress Jodie Foster, and the way he's going to do that is to shoot the president, and that's going to impress her. And so he does do that, and he is found to be insane. Now, remember, trying to assassinate the president is a federal offense, so that's a federal standard, whereas Jeffrey Dahmer is in Wisconsin. In Wisconsin, he's under a state definition. Furthermore, Wisconsin is not a death penalty state, so, and Wisconsin is one of those states that incorporates the irresistible impulses standard. Like, can you resist an impulse in order to act the way you should in the presence of an authority figure, which is what he did when the police came knocking at his door. So he was found to be sane. So Jeffrey Dahmer, who clearly, by anyone's standards, he kidnaps people, has sex with them, drugs them, turns them into quote-unquote zombies, that's the word he used, and then kills them and dismembers them and eats them. Well, I forgot the part about going into the refrigerator. He is found to be sane, where John Hinckley is found to be insane. So those things don't feel similar, okay? One of the cases that really made a lot of noise was the Andrea Yates case. And Andrea Yates was this woman who had a baby, and after her first child, she had post-traumatic stress syndrome. And the doctor advised her not to have any more children. She went on to have, I think it was 4 more kids. And then she drowned them in the bathtub. So she was found to be sane in Texas. There was a lot of different testimonies and stuff. And then ultimately she was found to be insane. Okay? But everybody wanted the death penalty for Andrea Yates, mostly because it's a mother killing children. And that really brought a lot of attention to the insanity defense at the time. Now remember, NGRI, not guilty by reason of insanity, is a defense of absolution. So once you are found not guilty by reason of insanity, you have no more penalty and you're not guilty. Okay? Now the state of Michigan was one of the first states to use GBMI, and GBMI is guilty but mentally ill. So you're guilty, you serve your time, you receive treatment. That's my cat. He's so rude. But you are still mentally ill. You receive treatment, you receive your sentence, and so GBMI is generally Michigan, but a lot of other states have adopted it as well. And a lot of people like GBMI because it doesn't absolve them of the crime. A lot of people don't like GBMI, but it is really necessary, and it is very historical. Since the beginning of legal structure in the world, we've always had a ruling of insanity that relieves the person of responsibility if they cannot appreciate the nature of their act or appreciate that the act that they did was right or wrong. And so this was something that was a really important mechanism. Now the punishment was always different than the sentence. So historically, one of the first cases was with the Queen, and she said that if you're found guilty, we would lock you up until the Queen's pleasure be known. In other words, forever. So there was that. So remember that the treatment is different than the ruling, okay, the decision. There's also a case in Michigan, was a very famous mental health law case where this individual, was Kamowitz case. He was found to have mental illness, and he was sentenced to a mental health center. And he went there and he served a sentence that was substantially longer. He was there for so long, longer than he would have served if he had just been found guilty of the crime. So he testified and felt he was better and felt it was time for him to be released. And he uttered the famous words, "I've been treated like a dog in a cage." Okay, and that resounded throughout the legal literature like a dog in the cage. And that made that case famous. And so they revised the law after that. We also have 4 main insanity laws that you're going to see. 4 main, or some pieces of those in all the different states. McNaughton, ALI, American Legal Institute, irresistible impulses, which I talked to you about before, was already Wisconsin. The Durham rule, these are all in your PowerPoint, so you should look them up, which came out of New Hampshire, Durham, New Hampshire. Rhode Island has the justly responsible, which is, does a person understand the nature of their act, and can they conform their behavior to operate within the confines of their responsible behavior? And if they can't, then they're going to be NGRI. So also we have Diminished capacity has been something that's been added. Intoxication is another one to consider. And we have a lot of big landmark cases that are presented in the PowerPoints this week. So you should check those out because they're really, really interesting. Another thing that we cover this week is involuntary commitment and civil commitment. And basically, involuntary commitment in a nutshell, for just about every state, has this component to it, is if the person presents a danger to themselves or others. And then once they are found, yes, they do, we're going to give you treatment involuntarily. In a civil commitment, you have to have the person be given the option for the least restrictive alternative. Anyway, what that means is that you can't just automatically say, okay, you're guilty here, we're going to commit you involuntarily, and we're going to put you in a straitjacket in solitary confinement. That would be a little harsh. So you have to do what is least restrictive, yet still comporting to the demands of that person's mental health needs, okay? So you have to look at those standards there as well. So this also applies, the least restrictive alternative also applies to things like restraints. Is the person eligible to have restraints or not? I had a client who had developmental disabilities, and he was always trying to harm himself. He did a lot of head banging, gave himself concussions, gave himself brain damage. He did a lot of biting, he bit himself all the time. And his parents, his mother was his guardian. And they were putting him in a posy, which is a restrictive jacket at night. And she went to court and said it was not the least restrictive alternative and got him to have physical restraints instead of the jacket instead. So you have to have an advocate sometimes to get that least restrictive alternative enforced. There's also in the PowerPoints this week the American Bar Association's mental health standards. So if you look at the difference between the DSM and the American Bar Association, it'll give you a good idea of how different they both are and how similar they are as well. So please make note of the similarities and the differences between them both. Also, one of the things we talked about last week was the right to assisted suicide. And I was asking in the discussion, what do you think about people who are just fed up, they're in pain, and they're just sick of all the treatment, and they just want to call it quits and, be done with it all. So we got a lot of interesting response for that. Thank you very much. I really enjoyed reading all of your responses. They're very interesting because you too will be encountering that in your practice. What are you gonna do? What are you gonna say? Does a person have a right? And all of these different things for civil commitment, because they do have a option for harming yourself or others, those all come to bear for that as well. So some things for you to think about this week. You can contact me again, give me a text by cell. I am going to go very far up north, very, very, very far, even with my bear earrings, because I do expect to see bear where I'm going. But anyway, I am not going to be out of your contact. I will have Wi-Fi, even if I have to drive into the nearest town an hour or 2 hours away, whatever. So I'm looking forward to a good discussion this week. This is a very interesting topic. If you want to take a look at the Andrea Yates case, I think that that's a good case for you to look at, and some of these other ones as well. So I will see you online. I will see you in discussions. You're doing really well. I'm very happy with your progress in the course. Great discussions on the Moodle, and I will look forward to seeing what you have to say. So, insanity, that's our topic. So, I will see you. And remember, it's a great day to be a dragon. See you next week.